Good morning, good afternoon, good evening to all of you, and welcome to the ILO's Research Seminar. Today we have with us Professor Antonio Aloisi, who is a professor at the law school at IE University in Madrid, Spain, and he's currently also a fellow at the New York University Law School in New York. And welcome, Antonio, to our research seminar series. Today, Antonio is going to talk to us about All That Shines Is Not AI, Regulating Algorithms at Work. And this seminar's actually, the talk that he's going to give is based on the recent book that he also co-authored with Valerio De Stefano, but also his ongoing work on algorithmic management practices in a number of sectors. So without much ado, I'm going to give the floor to Antonio to take us through why he talks about this fact that all that shines is not AI, to get us a bit more deeper into these thoughts, and also speak to us about how do we go about regulating algorithms at work. There's a lot of thought process that Antonio has put in, and I think I'm really excited to hear his thoughts about this. And Antonio, you would have 45 minutes to speak, and then we would have Q&A for another 45 minutes. So over to you, Antonio.
Thanks, Suma. Thanks a lot for having me. It's a real honor and privilege to have the opportunity to be here with the members of the ILO community, the large ILO community, and to discuss some findings coming from ongoing research, as you mentioned, and from the book that I co-authored with Valerio De Stefano, Your Boss is an Algorithm. I'm truly interested in your comments, your feedback, so I will leave some space for the Q&A. As always, this is a truly insightful moment of these seminars and events. The title of the presentation is as follows: All That Shines Is Not Artificial Intelligence, is not AI, Regulating Algorithms at Work. And actually, I would like to start with a reference to a prominent economist who has been studying this phenomenon, whose ideas are quite mixed when it comes to the impact of this transformative technology, which at the moment is very hyped. There are plenty of startups that are trying to market this technology, and policymakers, but also lay people are quite scared or excited because of the emergence of a novel and shiny technology. But as we are starting to experience, there are underwhelming performance and dangerous results that we should be considering. All in all, the Nobel Prize laureate stated that we could consider generative AI. He was particularly referring to one specific aspect of this technology as a so-and-so automation that displaces workers without bringing significant productivity improvements. And this is the starting point of a presentation, of a talk, that I will try and divide into three main sections. First, I would like to introduce the broader topic of automation at the workplace level, what we mean when we refer to a broad category of technologies, including AI, algorithms, and what we call, from a legal perspective, automated decision-making systems. To do so, I would like to broaden the picture and to first put this transformation in a historical perspective, trying to demystify some of the most apocalyptic scenarios that have been introduced in order to shape the narrative and steer the transformation towards a specific direction. Then I would like to share with you a more regulatory and legal overview of the measures that can be read in conjunction to offer some robust safeguards and guardrails. And here, perhaps the approach that I would like to adopt is not the common one, which is rather defensive, remedial, antagonistic. I would like to make a specific point, actually the idea that technologies that are introduced are often dysfunctional if they skip the steps that must be undertaken in order for them to be compliant with a set of rules that are introduced through several legal fields and measures, including data protection, anti-discrimination, safety regulation, and novel tools that have been just adopted, such as the prominent Platform Work Directive and the so-called AI Act. And then I will conclude with a more constructive and pragmatic session where I would like to present some co-creational approaches that can make sure that technology is not only efficient, but also functional for the purposes of bettering the working condition of those that are subject to it. Now, the first and only numbers that I'm gonna share with you are the following one. 47%. More than 10 years ago, an important paper was published by famous and respected economists claiming that by the next 10 years, so this is the perfect anniversary to discuss about that, almost 1 out of 2 currently available jobs would have been replaced, stolen, destroyed by technology. This was a rather worrisome concern that was presented. The same methodology was used by other co-authors or economists to try and figure out what were the prospects of currently existing jobs in terms of these activities being stolen by computer software. As you can clearly imagine, this figure was extremely exaggerated. But the problem itself is not with the number, of course, which has been proven to be wrong, inaccurate at least, but with the specific methodology that was adopted. And other labor economists, such as Daron Acemoglu, but also David Autor, have managed to explain that jobs are to be seen as a bundle of tasks. Only some of these activities can be either automated or augmented by technology. The important aspect, which is also the starting point of our book, is that there are 2 important fallacies that here we need to address. First of all, the current large availability of poorly paid and badly organized job is the key resistance to a large process of automation. To put it bluntly, we are not witnessing a very comprehensive process of mass automation precisely because humans are cheaper and more convenient than technology. And this is a concern that should interest us precisely because the key component of job quality can be seen as a defining factor on whether a job, an activity, a task is going to be automated or not. But then I would like to introduce a second number, which is 77%. And according to a recent survey that was published this summer, workers that have been using software and technologies such as generative AI. As you may know, these ChatGPT-like software are now pervasive. They have been introduced to streamline process, to support the drafting of emails and documents across the board in both factories and offices. Now, 77 of workers that have been experimenting with this software stated that they haven't seen an increase in productivity, but rather they have observed an increase in the workload. Again, this somehow resonates with the notion of so-and-so automation, which is not delivering on the promises that the manufacturer, the providers of these tools had made to us. All in all, what's the contribution that a lawyer can make to this conversation? First of all, people that are interested in the future of work cannot afford to disregard this conversation going on among the producer, the economist, and the quantitative scientists that are studying the phenomenon. There's perhaps an even more important aspect that can be added to this conversation, which is precisely the fact that we should be more concerned about the qualitative aspect rather than simply the numerical prospects and forecast about the disappearance of human work, or rather the potential, still unverified increase in productivity. So here the contribution is the following. Let's look into the concrete content and the effects and impacts that these technologies bring about in the context of work when it comes to agency, self-determination, ability to complete fulfilling, rewarding activities. Now, I would like to introduce a topic that I'm going to deal with in the remainder of this presentation, which is precisely the notion of algorithmic management. And one may wonder whether we are starting again with a reflection on the so-called gig economy. Actually, perhaps a very preliminary clarification on the terminology can be useful here. When we refer to algorithmic management, we roughly mean a set of tools and practices that have been first experimented in the context of the gig economy to manage the workforce. And the examples coming from these sub-segments of the labor market are many, from the GPS to follow and geomap riders when they are delivering a parcel or a pizza, to the evaluation that is left by means of customer reviews at the end of a performance, to the possibility of relying on dynamic pricing technologies, or even to the opportunity of excluding a worker from the platform based on the performance in terms of availability, punctuality, and so on and so forth. So, in a sense, to summarize, we could say that the platforms that were operating through a panoply of apps have been representing an immense open-air laboratory for testing and piloting and fine-tuning some specific features and functions that have now become prominent across the board throughout the entire labor market. Again, these have some consequences because when we look for algorithmic management, we tend to have a kind of confirmation bias. We want to find what we have seen in the platform economy. But as we have learned, the way in which authority is exercised may vary, may change. So we should use the platform economy and what we have seen in terms of feature and software to manage riders, couriers, freelancers, ground workers as a reference. But we should be also prone to expand the definition of algorithmic management to include some other models that may be less visible, more sophisticated. And this is perhaps an important point at the moment when we are starting to see a growing interest in the topic from an academic perspective, but also from a regulatory perspective. And these clarification could be somehow useful. Now that we have a kind of universally accepted definition, we should avoid being excessively restrict and narrow in the operationalization of this definition. So to conclude, what do we mean when we speak about algorithmic management? We can use a rather broad definition that basically take into account the full life cycle of an employment relationship, all the activities and steps and phases that are including between the two critical phases of hiring and firing. Everything that happens within the spectrum, including the very two functions of hiring and firing, can be to a certain extent offloaded to a technology. They can be partially outsourced to a software or fully, and this is why we talk in terms of semi-automated technology or fully automated technology. Now, to add something more, the issue that we're dealing with are much broader than the borders and confines of the platform economy. We see similar applications in brick and mortar sectors and industry. In warehousing, workers are constantly monitored to see whether they are picking the specific item to be shipped and delivered. In home office work that has spiked thanks to the experiment that was conducted, to the forced experiment that was conducted during the pandemic, we see a flurry of software that can be used to track the activities on a keyboard, the attention span of call center operators that are interacting with customers and can get a warning when the tone of their voice is too low or less convincing. When it comes to truck drivers, the same applies with some variations, of course. So some noises and sounds that can keep their attention high or notify them that they are going extra time in terms of driving. So the systems that were identified in a specific sector are now spilling beyond the domain of the gig economy. And this is why, paradoxically, we should consider algorithmic management not as a niche phenomenon, but rather as something that unites workers across the board. What is the legal challenge that we are faced with? First and foremost, in the book that we wrote with Valerio De Stefano, we try to theorize the genetic variation of employers' powers, of managerial prerogatives. First, the importance of the notion of managerial prerogatives and employer powers. As you may be aware of, the employment relationship is to a certain extent ambivalent for a specific reason. It both authorizes the exercise of command and control prerogatives, and it sets some limits, some safeguards, some due process-like measures and provision in order to make sure that the unilateral discretionary power exercised by employers, managers, is carried out in a model which is consistent with the rights and freedoms of workers in a liberal democratic system. Now, the current crisis that we're witnessing is the fact that new technologies, including AI, are altering this equilibrium of powers and check and balances. What is happening is precisely a qualitative transformation of the notion of upstream authority. This is due to the fact that these technologies can rely on inferential powers. They can both infer behaviors, they can predict activities, including attempts to unionize. And we have examples coming from the US where these software have been used to screen workers and to exercise activities of union busting, to make an example. At the same time, this technology prescribe behaviors by means of practices that have been described in the literature as anticipatory compliance. Workers that are able to internalize the penalties tend to comply with unwritten rules. This is where paradoxically authority is both obfuscated and magnified, and it can be much more complex to be detected by courts and by litigants. And then in terms of causality deficit, most of these technologies have been designed to operate at the level of correlation, which are even harder to spot. From a managerial perspective, there's another aspect that I would like to emphasize. Very often, when these technologies are introduced at the workplace level, there's a kind of path dependency, as economists would call it. Managers tend to over-rely this technology precisely because they are very expensive. They are introduced with the promise of being more objective, more neutral, less prone to biases or bribery, if you prefer. And this is where paradoxically humans stop exercising a kind of critical thinking in terms of the outcome of this technology. Something that is also exacerbated by the fact that in the community of designers of this technology, there's a lack of diversity, something that may calcify inequality and oppression. Now, going to the other legal aspect, it's important to take into account that the alteration of these power dynamics is happening at the level of the locus and temporal boundaries of the classical surveillance activity that has been always conducted by employers and managers. So when it comes to the debate as regards the continuities and discontinuities of this technology, we cannot avoid to consider the fact that there's a transformation in terms of scope, variety, velocity, and volume. And this is particularly concerning because the existing countermeasures, the controlling factors, have been tailored to a different form of power, a power which is more discrete, more human. And when it comes to comparing the biases, the flaws in automated and human-based decision-making, we should pause for a moment and first admit that humans in general are far from perfect. They make mistakes, they may be biased, but the problem that we have with technology is first that humans are accustomed to the idea of accountability. Humans know that they may suffer, human managers are fully aware that may suffer the legal consequences of a biased decision. On the contrary, technologies are mechanistic per se by default. They pursue a very specific goal in a mechanistic way without accepting exceptions, without considering contextual definitions. And then there's another important aspect, the impact of a bad management decision made by a human is rather modest, can spill out of control, of course, but in general, it can cover a limited amount of workers. When it comes to technology, the scale of the issue is almost exponential. Think of a software that is put on the market by a US-based company that is trying to measure personality traits or to infer the potential skill of the workers by means of a remote interview in the context of a recruitment process. These flaws that are embedded and ingrained in the technology, they may come from the biases of the programmers and designers, but they replicate themselves to a scale that is almost unprecedented. So this is perhaps a kind of bleak overview of the context in which we are operating. Are there any solutions? Here comes the more pragmatic part. Labor law is accustomed with the idea of power. Labor law has been designed to moderate the unilateral discretionary power of the dominant party. And actually, here I would like to say something on which perhaps we can open a discussion. We've been hearing for a long time now that when it comes to AI and algorithmic management, we have an issue of black boxes that are very hard to decipher because they are highly technical and sophisticated. We've been also told that it's virtually impossible to reconstruct the inner workings of a technology once a decision has been made, precisely because there's no way to reverse engineer a line of code. Here, perhaps we can try to decomplexify the debate. And perhaps if you listen to the internal conversation of the programmers and providers that are working on the technology, you may easily understand that the idea of making things more complex is also a rhetorical strategy to decrease interest and collective scrutiny on this matter. Now, we could arguably say that, in a sense, labor lawyers, practitioners in this environment, social partners are used to the idea of deploying tools that leverage the lack of transparency and information. Therefore, the excessive emphasis on transparency as a silver bullet may be somehow overblown. We could say that by leveraging uncertainty, we can put emphasis on the effects rather than on the specific causes of the problems. And if we place the burden on employers to deploy processes that are efficient, reasonable, but also reportable, we can force and compel them to better design technology, or even to discourage them from introducing off-the-shelf tools that are designed without being tailored to the specific needs of a specific workforce and population. All in all, we could say that by putting together some areas of law that I'm gonna discuss in a moment, we have the chance of using rights in order to change the decision. Whatever the decision to introduce the technology, to manufacture it in a certain way, to introduce some specific instructions, some particularly problematic databases, or to carry out some validation process. So here, humans that are making this decision are going to be liable. This is why the comprehensive set of rules coming from different areas, not only labor law, but particularly labor law, can lead us to a convergence towards more comprehensive and dissuasive methods. Let's consider here these convergence. Very often, we tend to address algorithmic management from a very narrow-minded perspective, which is compartmentalized. On the contrary, we could argue that we should adopt a function by function approach to algorithmic management, precisely because of the conceptualization that I attempted to introduce previously. Since algorithmic management is replicating, supporting, or augmenting human decision making throughout the entire life cycle, we can resort to legal frameworks that have been designed precisely to address these specific functions. At the same time, we should create a dialogue between some areas that are often disconnected and that are seldom considered in conjunction. For instance, data protection, which is mostly about crucial values and principles such as transparency, the data minimization or purpose limitation, the possibility of rectification, human overview, the right to explanation, should not be seen in isolation, but rather as a bridge to non-discrimination provisions that are used to restore the rights of those that have been wrong because of the adoption of technology or practices that result in unfairness, on inequality. On top of this, we may also use some ideas and principles coming from safety regulation, which is precisely the model of the AI Act that perhaps we can discuss in the Q&A as well. So to provide you with a more integrated framework, I would like to present how these interrelationship can be operationalized in practice. As you may know, the GDPR framework, which is kind of relatively novel, it has been adopted in 2016 and entered into force in 2018, is currently offering multiple resources to litigants, to trade unions, to legal hackers that are bringing several successful lawsuits before courts or claims before data protection authorities that in turn are becoming very familiar with the inner working of this technology. So we could put together some interesting provisions. For instance, the ban on processing sensitive data pertaining to protected characteristics with some other important rights in terms of information and access. And here I would refer to Articles 13, 14, and 15 of the GDPR. These rules are particularly effective because they mandate for the information about the existence of automated decision-making system and the information about the underlying logic. So basically some metrics, some information and criteria, proxies must be disclosed to these data subjects that in the workplace context are almost invariably also workers. Then the classical resource is the ban on automated decision making that can be found under Article 22. We've been also criticizing this provision because it includes important exceptions and carve-outs that devoid workers of these protections based on the existence of an exception that is called the contractual necessity or the legitimate interest of the data controller. But as I mentioned previously, all these resources must be put to the service of non-discrimination, which is a particularly effective system of rules, which can kind of resonate with how algorithmic management tools operate in concrete. First of all, the equality framework is mostly concerned with the effects rather than the causes. That's why I argue that there's no need to open the black box with all the recurring sophistication that it entails. We just need, in terms of procedural rules, the alleged victims simply need to bring a prima facie case of discrimination based on some elements that are plausible yet not conclusive. These implies a shifting of the burden of proof onto the presumed violator that is offered the opportunity to document and explain that a discrimination has not occurred, or that in case of indirect discrimination, that indirect discrimination was justifiable because of the goals it was pursuing, and that the means by which such a goal was attained were necessary and appropriate. As you can see, the framework of equality law is quite flexible, but the resources coming from data protection, the data protection impact assessment, the rules on access to the underlying logic, the information rights, the opportunity to contest a decision can be read in conjunction with equality law to offer some resources to litigants, to trade unions, and worker representation bodies representing workers to force the companies to introduce technologies that are rational, documentable, that can be also used to make decision makings, the way in which managers go about choices at the workplace level, more contestable and reviewable and documentable. The final point is that, as we may all know, as I introduced previously, AI works in a way that is much more complex than the classical model of discrimination. But here, from a legal perspective, we can rely on some very progressive and forward-looking judge-made notions of discrimination by association and discrimination by proxy that can be used to broaden the protection for some factors and indicators that are not customarily protected under equality law, which is rather narrow when it comes to the catalog of protected characteristics. Now, approaching the conclusion of this presentation, I would like to emphasize the key importance of the fact that workers are not defendless. And here, what I've tried to share with you is a fully fledged catalog of existing resources that can be mobilized regardless of the flaws and the limitations in these frameworks. They can be updated, they can be adapted by, as of now, they are already available. And here, the perhaps almost final contribution that I would like to make is as regards the dimension at which we should address technologies at the workplace level. Very often we tend to forget that data at the workplace level are never entirely personal. There's an implicit data network effect thanks of which the data about one single worker can be used to infer and predict characteristics, traits, behaviors, skills at the level of communities and population. This means that the collective dimension, which is very prominent in labor law, is the dimension at which technologies can be tackled in a very efficient and effective way. This means that we could reinvent or strengthen the enforcement of classical resources such as information and consultation. In some countries, as we know, these rules are even boosted in terms of co-determination prerogatives and veto power. Some schemes, for instance, the German legislation, have been updated to introduce co-determination on AI tools that are introduced for hiring purposes. This means that workers can be aware of the existence of technologies that perform managerial prerogatives, and they can question their viability, their effectiveness, and the way in which they operate. There are some other more adversarial items that we should consider. The opportunity of litigating algorithmic management tools, filing claims before data protection authorities. This week, the Italian Data Protection Authority fined a large food delivery company precisely because the internal technology was not compliant with the GDPR in terms of using and collecting data even when workers were not concretely offering their service on the app. But the collective dimension is very apt also in terms of facilitating fact finding and sharing information. Worker representation bodies are perfectly equipped to collect information when it comes to the course of new vacancies and people that have been hired in terms of the allocation of slots and shifts. And this information can be instrumental to make transparency actually relevant at the workplace level. And here, the catalog and the examples of strategic litigation is growing day by day. Several institutions, including the ILO, have been putting together some databases of successful litigation or guidance on how to successfully bring this claim before equality bodies, data protection authorities, and conventional labor courts and tribunals. The very final point, and I want to be diligent with the time that I've been allocated, is precisely about co-governance of workplace technology. This is something that is not a wishful thinking. It can be found in existing resources, as I've been mentioning. Article 35 of the General Data Protection Regulation mandates for the so-called data protection impact assessment, which is a continuous collective endeavor by which all stakeholders can participate in the identification on the identification of the risk to fundamental rights that a data processing technology can create at the workplace level. These tools should not be seen as one-off exercises of checking boxes, but rather as an opportunity to responsibilize the producer of the technology, the adopters, meaning managers and employers, and those that are subject to this technology. The principle of involvement is a cornerstone of European Union labor law. It means that those that are subject to a specific decision must be made part of the decision-making process. A similar logic can be found also in the AI Act that can be criticized for the internal logic that is almost entirely based on the risk mitigation system, according to which basically technology get a green light as long as they comply with a set of provisions that are documented in this regulation. And the purpose is precisely to minimize risk, whereby in some cases they cannot be entirely eliminated. But even in this piece of legislation, which pursue market liberalization goals while protecting fundamental rights, we can find something similar, the so-called fundamental rights impact assessment, which operates in a way that is consistent with the data protection impact assessment. In addition to this, the deployers of these AI systems are also compelled to notify worker representatives when they are introduced these tools at the workplace level. So there's a kind of consistency in the legal framework which corroborates the idea that these technologies can be made somehow relevant for workers. They can be used to enhance transparency, to strengthen the compliance with health and safety legislation, which is something that is predominantly neglected, although it is becoming super relevant in terms of psychosocial risks that are exacerbated by certain uses of technology. All in all, the approach that should we adopt could be described along the lines of, if technology cannot be uninvented, we can leverage legal resources to make sure that these tools are not only convenient for those that design and market them, but also functional at the workplace level. Co-designing this technology is also a terrific opportunity to make sure that there is a kind of overlapping between the designers and those that are affected by these tools. In this way, noisy, dysfunctional, non-representative data and metrics can be eliminated, and workers can profit from the benign uses of these tools. Thanks a lot for your attention, and I look forward to engaging in a fruitful conversation.
Thank you so much, Antonio, for this very fascinating presentation. And I think you have opened up a number of issues, a lot of food for thought, and a lot of tools. And I think we are sitting at the ILO at the moment, which is a center for social dialogue, which is what our bread and butter is in a way, in trying to navigate these tools and technologies and to see how we can protect the workers. There are a couple of questions that are coming in. So what I'm going to do is basically pull these questions to you, and I have a couple more from my side. And I'd like to ask all the participants, whatever questions you have, please put it into the Q&A and we'll get it to Antonio. So there's one thing that you haven't really talked about, Antonio. I guess it's because of lack of time. And if there is time permitted, I do want you to reflect a bit upon the EU AI Act, which is another body of labor regulations or labor regulatory tools that can be utilized to protect the workers, right? So that's one thing that I do want you to address whenever, if time permits in the end. The first question is from one of our colleagues from the Employment Department, Michael Mawasikata, who's arguing basically that the changes in the technology are very fast, while that of the labor law is quite slow and it changes quite less frequently. So how do you actually address this entire challenge? Because that's much more about customization to functions and how do you put it in practice? And the second question is from Elizabeth, who's in Mexico office. She's saying that normally algorithms are not public. How can strategic litigation target something that is protected by intellectual property or other means? Rather, I want to just add to that that the algorithms or the source code of the algorithms are protected by the trade treaties, which are under the WTO. And the fact that, and I guess part of the reason why it was the way it was under the trade treaties is because it's kind of a business secrecy, right? But the minute this kind of a business secrecy does have an impact on labor, how do we actually bring that within the labor regulation and labor law? So I think these are first round of questions, and then we'll take on the second round. Thank you so much.
Thanks a lot, Uma, and thanks for these questions that are to a certain extent interrelated. And I perhaps could start from the question by our colleague about the potential obsolescence of labor law, or at least the inability to keep pace with the transformative impact of technologies. This is particularly connected to the issue that you raised, Uma, and that we had not time to delve into, which is the AI Act. Now, a classical discussion as regards the ability of legal tools to keep pace with technological tools is framed precisely as it was mentioned previously. This phenomenon, this environment is very fast-paced, while when it comes to introducing or even simply updating a legal provision, it may take ages. And by the time that we successfully introduce or fine-tune a line of text, the technology has already taken different forms. This is precisely the point on which we could criticize instruments such as the AI Act. The best way to make sure that law and innovation are mutually reinforcing is to rely on so-called technology neutral legal provisions and regulation that deal with the functions rather than with the means by which those functions are exercised. Without entering into the risk system, that is something on which we can comment on, the AI Act can be precisely criticized for this very laser sharp focus on a specific technology, which may technically disappear in the near future, disappear in the sense of evolving into something more sophisticated, better, or more attuned to the needs of citizens and customers. A similarly framed criticism could be addressed to the so-called algorithmic management chapter within the Platform Work Directive. And there are some commonalities here. The AI Act simply addresses one specific technology, AI, defined in a very specific way. The definition has been expanded. It is drafted upon the OECD notion. It can be interpreted in a kind of broad manner, but the focus is simply on this specific technology. The state of the art is somehow encapsulated into the regulation. Similarly, the Platform Work Directive is very progressive in nature. The algorithmic management chapter includes some red lines, some limitations, some bans on the use of automated decision making and automated monitoring, but it simply limits these forward-looking provisions to the context of digital labor platforms, defined in a very specific manner when there is a notion of control, when the platform is to a certain extent organizing the underlying business. Now, while the Platform Work Directive must be praised for being the kind of unique effort and experimentation into limiting the unordinate explosion of this software, it does so with a very sector-specific approach. Some could argue that this is just an experiment, a test for some provisions that could be expanded. And there are several scholars, some of them are connected here as well from what I can see in the chat, that have been arguing in favor of this opportunity, broadening the scope of the algorithmic management provisions in the platform platform work directive to cover all workers, regardless of the sector where they are operating. So to conclude a very fascinating discussion, as you can tell from my emphasis, I would say that first, we must acknowledge that regulation can go hand in hand with innovation. And there are several evidence of this. The risk of law lagging behind the curve is often emphasized as a rhetorical weapon to dismiss the existing provision and to freeze the attempt to introduce new tools. And then the best way to achieve these goals is precisely to focus on the functions, on the activities performed, rather than simply narrowing down to a specific tools. We've been regulating, in a way, we could say, the act of writing rather than the pen thanks to which we write. And this is an approach that we could adopt. And then there was a reference to the inner working of algorithms, the fact that they can be considered as trade secrets. And to a certain extent, they may be in some cases, something that goes also in conjunction with the fundamental right of freedom to conduct a business, which is protected within the European Union legal framework. But of course, this is true in several jurisdictions. Here again, the approach that has been taken so far is perhaps misguided. No one should be truly interested in the line of codes that define an algorithm, the way in which it works. We should compel the producer, the providers, and the deployers of these algorithms to make these tools understandable to those that are subject to them. And here I would like to say something important. Good employers, responsible employers, are constantly exposed to several risks in terms of loss of know-how, in terms of cybersecurity, in terms of risk of basically having the wealth of knowledge somehow stolen, scrapped by these tools. We have now seen how generative AI systems have been manufactured, for instance, by technically scraping all the entire web, including some copyrighted information, right? These legal risks that employers are facing should be used as a bargaining chip to say, Of course, this technology can be protected in terms of intellectual property. They can be protected as trade secrets because of the fundamental technology at the basis of these tools, but the consequences they causes must be regulated. And to address such a consequences, including and enforcing rules on transparency, explanation, review, oversight, is something that is going to be beneficial for employers. The standard model is not a large Silicon Valley corporation designing a technology. The most common scenario is a small and medium enterprise, which is somehow dealing with a fear of missing out on this technology, that is leasing or renting or buying this technology without understanding it. So perhaps when we discuss about lack of information, black boxes, we should include responsible employers in the conversation. They should be concerned in the first place because they risk losing control over critical processes throughout their internal value chain. So all in all, we don't need to unpack, decipher, and decode highly sophisticated tools, but rather to put the emphasis on the effects, on the consequences. And these activities have been always regulated when it comes to shift allocation, working time, work organization, the rest time, the compliance with occupational health and safety, the attribution of rewards, promotion, who is hired, the rules by which disciplinary mechanisms are enforced at the workplace level, by which of proceduralism or process-based law. This is very classical and almost basic in the context of labor law and human resources management. So perhaps something that we should be doing is to de-emphasize the technological facade and to look into the specific functions that are performed. And in this case, our traditional resources are apt, prominent, can be fine-tuned, but they have been always mobilized by a large coalition of players, including worker representatives, trade unions, but even employers that whenever they buy a technology, they make the decision to introduce a technology, they want to keep control. The final point is that we've been perhaps buying into a techno-deterministic approach, according to which we look at this technology as something fully obscure. There are important scholars that have been discussed this in terms of shamanism, the over-reliance on this technology. They are complex and sophisticated, but the key decisions behind the introduction, the adoption, the decision on how they should pursue certain goals are made by humans. And here we have resources that can be mobilized.
Thank you so much, Antonio. And I would just like to have your thoughts on de-emphasize the technological facade. Traditional tools should be mobilized. I think this is a very, very important point. And I do want to come back to that in a minute. We have a couple of more questions. The three that I do want to pick up, they go in different directions, but very much involved with the work that we have been doing in the research department as well as the ILO. The first is from Halefom. Nice to see you here. And he likes the integrated approach that you put together, Antonio. And his question is, do you think whether the overlapping of the different legal regimes, that is the labor law, equality law, and data protection law, dealing with algorithmic management could also create problems? For example, he says, do you think the multiplicity of regulatory authorities with overlapping functions could lead to confusion about where and how to comply? And I think this is a very, very valid point here. The second question is related. It's about the platforms, and it comes from Laura Leongozi, But he was asking, do you think platforms are too big to be regulated when it comes to the use of AI and human monitoring by platforms? And the third question is from the Ministry of Labor in France, Charles Molgo, who's asking you, how do we go about regulating, which is my pit question too, the working conditions and supply chains of AI's major actors, which is another round of issues that needs to be handled. And how do these existing mechanisms actually deal with? So over to you.
Thanks. It's a collection of questions that entail lots of reflection, but I would start with the complexity of the architecture that I've tried to present. It's true that including and integrating several resources may be seen as a potential risk in terms of steps that must be completed and achieved. My point when it comes to the integration is that the role of these tools should not be seen as simply remedial, as an ex post damage control. Something that we should here emphasize is the opportunity to improve technology by deploying a preventative, ex ante, and participatory, or rather collective approach. These rules on transparency, on the right to rectify, to object a totally or semi-automated decision, the rules on non-discrimination, which are, of course, are to understand, interpret, and enforce, must be seen as an encouragement, as an incentive for designers and adopters of this technology to take these into account when designing, marketing, and introducing this technology. I'm not considering these legal resources as tools to be simply mobilized before a court to rectify a problem when it has arisen. On the contrary, more understanding of these rules could entail better technology in the design, deployment, and development phases. So to complete this reflection that was somehow triggered by Alefom's point, it's true that we've been discussing a lot as regards the limits of existing legislation. I don't need to insist on the gaps in instruments such as the GDPR, which is not entirely covering semi-automated decisions, which is not covering these decisions where they are not legally or similarly significantly affecting data subjects. We could discuss about limited catalog of protected grounds in the equality systems. But here, the opportunity that we have is to make these rules visible to the deployers, the designers of the technology, to force them to embed these principles in the software. Then there was another point related to the value chain of complex systems, and in particular in the examples of technologies that are rented by players that are based in different jurisdictions. And here, the work that has been conducted at the International Labour Organization is truly and extremely important, precisely because colleagues have been putting some emphasis on the involvement of workers that are based in the global south. We could consider AI as a process rather than a single technology. In this process, there are annotators, there are data labelers that are involved besides the players that we are used to think of in terms of workplaces in the global north. Here, there are some resources companies as well. I briefly mentioned the Platform Work Directive that takes a broader perspective on the issue by limiting some applications. So basically by outlawing some of these tools. The same rule can be seen in the AI Act. Some specific practices, for instance, biometric identification, with some exceptions for medical and health-related purposes, are totally banned. So we should be somehow confident as regards the fact that some of the most nefarious and utopian uses can be entirely banned. At the same time, in the context of the European Union, we can also rely on newly adopted legislation, in particular, the directive on corporate responsibility due diligence and the duties on reporting as regards these responsibilities. Again, here I see the classical criticism when it comes to due diligence and reporting, the fact that these activities are mostly exercised in a performative manner. They create an illusion of compliance by introducing what has been called a bureaucracy theater. But if enforced, transposed, and implemented in the fair and right manner, these new directives on corporate social responsibility and accountability and due diligence reporting can offer the specific platform to introduce analysis, risk mitigation strategies, and improvement strategies as regards several items throughout the entire value chain of the AI software. Several considerations can be introduced thanks to these directives that applies to large companies with some numerical thresholds that I don't have time to discuss, but actually concerns for human rights, fundamental rights, including labor rights, can be, of course, discussed and addressed thanks to these tools, together with other considerations that have not been the focus on this presentation, but here, for instance, we could also discuss as regards the environmental effects of AI systems that are very energy draining and needs a lot of computational power that in turn is fueled by servers that are located in some countries. Again, the process of reporting and making this risk explicit is a terrific platform for making all these correlated aspects visible in an attempt to rectify and improve the risks for workers, the environment, and companies as well.
Thank you so much, Antonio. There are two more questions from the audience, and I'm going to add at least one from myself. The first is from Ana Rosa Pisole from InWork, who's arguing basically that governance based on DPIA or similar assessment outputs is mainly a corrective power. It does not involve an active participation of workers in the decisions, and it does not involve open the black box necessarily. But don't you think co-governance should be extended to protect workers' participation and not only safeguarding the already existing rights? If yes, how? I think you were already talking around those lines, in my view. The second is from Satya Seelan Janani, who's saying that regulating algorithms is an untouched and unnoticed area in the global south, while algorithmic management is happening. What's your opinion? And related to it is Gamelile Sibanda. Given the developers of the algorithms often cannot explain how the algorithms arrived at the decisions, how do you think organizations can deal with a situation where developers provide a complex explanation that normal people do not really understand? And what he's talking about is a malicious compliance where explanation is provided, but the end users do not have the capacity to understand. I think I'll allow you to answer these and then you take my question. Thanks.
Okay, yes.
Over to you.
Again, I'll try to be brief, and perhaps if there is an important takeaway that I would like to share with you is related to this final point, the issue of complexity, the problem of decoding the technology, or even the complementary risk of overloading companies and people with paperwork and dozens of data points or explanation precisely in order to bury any attempt to learn something more. Again, this is perhaps the point where I introduce something that may sound contentious, but in ongoing research, we have been trying to argue that to a certain extent, a specific fascination for transparency per se may be exaggerated, right? Transparency is not a goal. Transparency is a means to exercise other rights, rights in the area of collective labor rights, rights in the other spheres of the labor domain. If we look at transparency in terms of an instrumental element in a more complex architecture, we may somehow uh, rely on the tools that we've been considering. So I totally understand the risk of creating a system which is more bureaucratic than effective. To a certain extent, the same risk has been documented in the area of data protection. There are some tools, there are some provisions that have been weaponized by some operators, by some players, precisely because if you want to show compliance with a certain provision, the player may create lots of information, due diligence reports, documents that result in suffocating the data subject or the final client that could also be a company. So again, if we restore an instrumental value of transparency, perhaps we may look at the moon rather than the finger that is pointing at the moon. We are interested in the moon, not in the finger. Transparency is just the finger. We want to make these technologies understandable, documentable. We are not at all interested in the line of code. This would entail also some technological skills that workers are not necessarily obliged to master. We have also some kind of limitations when it comes to dealing with our own software that we use on a day-by-day context. I don't want to know what is behind the interface of Zoom. I want to be made aware of whether Zoom is recording this conversation, whether the language and the conversation has been transcribed and used to fuel some generative AI tools. And if so, I want to exercise my right to object or to stop these practices if applicable. A more sophisticated understanding is not necessarily something that could strengthen the exercise of such rights. And then final point on the co-creation, I'm totally with Anna Rosa when it comes to considering these efforts and these practices not as remedial, not as exposed, but rather ex-ante opportunities to decide on whether a technology must be introduced or not. here, perhaps the point coming from sociological studies, from qualitative understanding, from case studies that have been conducted, is that workers are perfectly equipped to decide what is better for the efficient running of the business. We've seen this in the context of the pandemic, but this is happening constantly. Workers, when afforded with unsupervised autonomy, are prone to make decisions that are entirely beneficial for the company itself. So perhaps here we are missing out on the terrific opportunity to mobilize this know-how of workers. And this know-how can be perfectly leveraged to decide whether perhaps a specific practice is much more efficient if conducted by humans rather than technology, because human can exercise discretion, flexibility, and can distinguish with a kind of emotional intelligence or mental dexterity what is better for the company itself.
Thank you so much, Antonio, for those responses. We have about roughly another 7 minutes, and I'm going to put to you, as there are no more questions from the audience, two from my side. I want to get back to your de-emphasis on technological facade and traditional tools should be mobilized. And I think I also like the way you talked about, especially in the context of, the AI acts or the tools that come about, how they refer to certain particular tools, while when you get into the traditional workplaces, there's a whole range of tools and technologies that are there that go about managing workers. And this is something we also find in our research. But the question I have is, based on the work that we have been doing at the ILO, especially in the automobile and the electronics sector, all that we are talking about, saying algorithmic management or algorithmic governance, is something that has existed right since the mid 1980s and 90s, both in these sectors as well as in the call center industry. And my question to you is, to what extent have the traditional tools that we've had been able to address it, or is it that this was left in a vacuum and it's coming much more into the fore now that we are getting into this discussion saying automated decision making, algorithmic management, and algorithmic tools? But this is something that's there. There's very clear evidence that we are picking up actually from our work from the 90s onwards. So how is regulation been dealing with it? That's one question I have. Number two is, it's very interesting to see that GDPR has a lot of articles that can be used to actually stop automated decision making. But again, the research that we are doing comes about to show that there's a lot of automation that is happening, but depending upon the country and depending upon the sector, you do not see that being put into force. So, it's either the work councils in Germany or collective agreements elsewhere that sort of stop. So I also want you to reflect a bit there as to, is it that we do have some acts and tools, but workers are not really aware about it? And
Yeah.
they do not even know how to utilize it within the workplaces. And I think you do end very well with saying workers are not defenseless and it's all about information and consultation. But how do we make this more obvious, or how can it be used in a much more proactive way that we can actually stop the automated decision making in a way? Because you do have Article 22 very clearly, right? So I think I would love to have your thoughts on these two.
Yeah, thanks a lot, Uma. And perhaps we can start again with the admission that if we stick to this function by function approach, there's very little entirely novel and original in algorithmic management. So here again, I don't want to stress the importance of terminology, which may of course encapsulate some understanding of the reality. But if we stress the management section of this definition, we may end up realizing that management functions have been digitized for a long time now, right? If you go back to the 70s of last century, with the emergence of computerized instruments or automated robotic tools, machineries at the workplace level, we witness precisely the same concern, or at least the nature of the legal issues that emerged at the time are entirely relevant nowadays. We should also take into account the enhanced scope in terms of volume, velocity, variety. There's something in terms of the strength and power of this technology that is to a certain extent unprecedented, but the activities that they are completing are profoundly trivial. They are deciding who gets a promotion based on certain behaviors. They make a decision on how to allocate a shift. In the past, this could have been done by using a simple Excel file in the context of the health sector, where people have been long addressing the erraticity and arbitrariness of certain decisions. So what is truly not unprecedented is the problems, issues, and uncomfortable situation that the adoption of some automated, partially or fully technologies bring about to the world of work. And this is perhaps we can adopt a kind of technology neutral, almost conservative approach to pause, stop, and claim that the legal framework should not be updated every single time there's an update in the iOS technology of our iPhones, right? Rules are precisely designed to be general, to deal with unforeseen conditions precisely because of the open texture nature that make them prone to interpretation and to adaptation to the evolving landscape of the businesses and the technological environment. The examples that you raised, the automotive sector, the health industry, but the other context where these erratic, arbitrary technologies have been introduced are many. This basically reinforces the idea that by going beyond the overhyped enthusiasm for this technology, we can adopt a more rational, critical, and realistic approach to these tools. Then the lack of enforcement. Something that perhaps I have not clarified is that those rules that on paper look terrific in addressing some of the risks have a crucial issue in terms of enforcement. This may be attributable to several problems. There's a lack of knowledge. There are some legal obstacles. There are some expensive and costly steps that must be completed. There's a lack of institutional support for the players that are expected to mobilize those provisions. Now, if we want to conclude on a mixed note, we could say that lawyers, and in particular labor lawyers that are starting to become data protection specialists, are now able to both praise and criticize the GDPR. Again, a comprehensive overly detailed and fit-for-purpose instruments, including so many limitations that apply to the workplace level. Perhaps this could be the topic for another seminar, but the framing of the Platform Work Directive, and in particular this section on algorithmic management, is a perfectly drafted regulatory fitness exercise on the inefficiencies and deficits of the data protection system when it comes to the workplace level. So we should be able to exercise a complex thinking by claiming that the data protection resources are valuable and must be somehow enforced. They are, to a certain extent, even novel. So we are approaching the ascendant part of the learning curve after some years, but at the same time, the exceptions, the carve-outs, make it vulnerable to abuses and not unscrupulous exploitation by some players. This is why we could conduct a kind of surgical exercise to close the gaps and fix the loopholes in the existing legal frameworks. As a final point, the topic and the area on which perhaps we can invest our energies is precisely the opportunity of fixing the GDPR model by using the template of the Platform Work Directive that is that has been designed precisely as a fine-tuning tool for the data protection framework that is partially ineffective at the workplace level and in professional ecosystems.
Thank you so much, Antonio. I think I like this very point that you made. How do we close the gaps and fix the legal loopholes to ensure that the workers are protected as a result of it in the workplace? And I think with this, I'd like to thank you very much for this very fascinating talk and very fascinating discussion. Thanks to all of them in the audience who participated in this. And we look forward to engaging more with you as we move forward in this subject. Thank you very much and see you all in the next
Thanks to you,
seminar, and wishing you a very nice evening. Thanks a lot.
Bye. Thanks
Bye.
to the audience as well.
Bye.